and not be able to rejoin.
Yes. Okay, so we will get started now then. Mr. Cornelius, you can hear us, correct?
Yes.
Okay, perfect. Good morning. I am P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. This revocation hearing concerning Cornelius Charles, number 296776. Today is March 19th, 2025. This hearing is being conducted via video at the BOPP Central Office in New Haven Correctional Center. This is a public hearing, public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Charles Cornelius, 296776.
And we have a parole supervisor present. Please identify yourself for the record.
Absolutely. My name is Micah Mann. I am a parole supervisor with Parole and Community Services of the Department of Corrections.
And we have counsel here today. Can you please all identify yourselves for the record?
Yes, this is Genny Eric Creizman, and Christina Gotsis from Morrison Cohen on behalf of Charles Cornelius.
Thank you. And just to note, we also have a witness who is present today. Can you please identify yourself for the record, sir?
Yes, my name is Panasan Tongmei-Vong. I'm correction officer with Connecticut Department of Corrections.
Thank you. So this is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence. That is, the better weighted evidence must establish that more probable than not the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your parole, which is Elysium, and place you back on parole supervision. If I find you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state your parole officer is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present a relevant testimony in any relevant documents. After the state is finished, counsel will have the same opportunity. After considering all the evidence presented, I will announce my findings. If I find you have violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, counsel will have the same opportunity. Do you have any questions about the purpose or procedure before we begin, sir?
No.
Okay, you have important rights today. The right to have an attorney present, and you have counsel here today. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
I don't know.
Counsel, did you review the violation with Mr. Cornelius?
Yes,
Okay.
yes, we have.
You have a right to view the evidence against you before the hearing. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights, and are you ready to move forward?
Yes.
Okay, so we'll now review the charge the state your parole officer is bringing against you and the information underlying each charge. So P.S. Mann, please read the charge. Oh, you are muted.
Thank you very much. Yes, so charge number 1 under weapons. On December 26, 2024, New Haven Police Department executed a search warrant of a storage unit at self-storage of Stratford that was in your name and that you had control over. Found during this search were several knives that are over 4 inches in blade length, consisting of a switchblade and or a metal knuckle. Your GPS placed you at this location as recently as 12/22/24. On 12/26/24, a search of your residence was conducted by Parole and New Haven Police Department. During this search, 6 knives, which are either over 4 inches in blade length, consisting of a switchblade and or metal knuckles, were found at your parole-approved residence in areas that you were able to access. All but one of these weapons were located on a kitchen countertop in plain sight next to your identifying information. This is a violation of your parole conditions. Specifically, I will not use or have in my possession or control any firearms, ammunition, or any other weapons.
Thank you. And the state has
welcome.
filed the following exhibits that are pre-marked for identification purposes as the evidence was put in the record at the time of the preliminary hearing. That evidence remains. There is additional evidence that was submitted by the state, which is Exhibit H, which contains additional photographs. Exhibit K is an incident report supplemental. Exhibit L, supplemental updated. And Exhibit M, which is the at-night GPS map. Did you receive notice of parole violation report, and the other documents I marked for identification, and did you review that information, sir?
Yes.
Okay. And defense counsel has filed the following exhibits pre-marked for identification purposes as defense exhibit 1, risk protection warrant, exhibit 2, defense exhibit, first request potential defense exhibits, exhibit 3 from defense, second request witness. Exhibit 4 is alleged latex gloves. Exhibit 5, alleged camo can. Exhibit 6 is side of alleged camo can. Exhibit 7 was 8/28/24 Cornelius letter. Exhibit 8, 9 are storage locker photos, storage bin photos. Exhibit 10, exhibit 11 is picture of organized storage box. Exhibit 12 through 17 is organized collectibles and envelopes. Exhibit 18, 19, 20, pictures, Jan Hafnick with aged, his picture of knife. Exhibit 21 through 23, defense exhibit, protect mammoth pictures as well. Exhibit 26 through 27 are pictures of Walton mammoth. Exhibit 30 to 32, Walton mother of pearl photos. Exhibit 33 to 35, Walton Timicus photos. Exhibit 36 was the American Edge invoice. Exhibit for defense 37, 2024 early termination package, letters and article. And exhibit 38 is the Charles Cornelius motion. So all these were reviewed as well prior to this hearing. To defense, do you need to continue the hearing to obtain any additional evidence?
This time, Your Honor. I mean, not at this time.
Oh, what was that? No, okay. Sorry, you cut out. So at this time, the witness has been called by defense to be here today, which is CEO Fansong.
I don't know when you would like me to do this, but the state does have some objections to allowing this witness to testify.
All right, so first of all, there's no other witnesses that are being called today other than the CO that we have present today? Is that
For the defense.
what was that? Sorry, you cut out.
I said not for the defense, and I'll put it on the record that we may not ultimately ask the correction officer any questions at this proceeding, but we wanted to make this individual available should the need arise during the hearing.
Okay, so PS Mann, what is the opposition to him being here?
The state strongly believes that CO Tong Manivong's testimony is immaterial and really repetitious of any testimony that I am going to present.
Okay, so at this time, there's no problem with, I find no problem with him being here present, so we'll move forward with the hearing. So at this time, the state is going to have an opportunity to call witnesses, present evidence, and speak to any of the evidence submitted at this time. So PS Mann, I'm going to swear you in, as well as Mr. Cornelius, in the event he would like to speak today. Can you both please raise your right hand, as well as CO Thomavong, just in case you do speak today, please raise your right hand. You solemnly swear, solemnly affirm, as the case may be, the evidence you shall give, so in this case, shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
I do.
I do.
All right, so at this time is the state's opportunity to speak, if you'd like to at this time.
Absolutely. So at the preliminary hearing, Parole and Community Services presented the evidence that we had regarding Mr. Cornelius violating his parole conditions regarding possessing weapons. At that time, defense counsel did not really object that this violation occurred. I don't think nobody has stated that Mr. Cornelius did not have said weapons. The state further proved at the preliminary hearing under state statute 53-206, many of those weapons are considered dangerous weapons under Connecticut general statutes. Therefore, I don't think any of that was really contested. Defense presented a case that really hinged upon that these were weapons that Mr. Cornelius had no intention to use, and the seriousness of the nature regarding the weapons. Subsequent to the preliminary hearing, we also have submitted evidence, and I just want to also point out, I should have said this at the beginning, that due to the sensitive nature of these additional addendums that we have submitted into evidence, the state is requesting that, at least for this public hearing, that any names that were included in that evidence, and specifically addresses, private addresses that were included in that evidence, that we don't verbalize those names during this hearing. That evidence was extremely private in nature. It contained employees at both the Board of Pardons and Paroles. It included parolees here at Parole and Community Services, and it included the children of employees at Parole and Community Services. So we would kindly request that names and addresses specific to that evidence is not shared during this public hearing. Having said that, in regards to the serious nature of the weapons that we found,
that'll be for the second part of the hearing regarding seriousness. If you have anything else just regarding the charge,
I will bring it up then. Go ahead.
So it is now defense's opportunity. If you'd like to call witnesses, present evidence, or speak to any of the evidence submitted at time regarding the charge.
Officer Meister, we do, and I think we're going to do this in two parts. I think my colleague Eric Creizman is going to go first, and then I will also make some arguments later on. But Eric, take it away.
Good morning, and I'm sorry that I can't actually see what's going on, or you can't see me either. Maybe that's a positive for everybody, but let me just begin. Okay, I've represented Charles Cornelius for 14 years, and I've gotten to know him very well. I've got to know the opportunity to know his family. I knew his father for several years. I knew know his mother for all this time, and this is an emotional case for me because I know Charles so well, and I know his mother so well, and it bothers me that I think that he has been profiled and mischaracterized as a dangerous person for so many years. And the fact of the matter is that this assessment is really based on no evidence, and I want to go into that a bit. But let's start with, let me tell you who Charles Cornelius is, because since he's been out, would this go with the second part of the hearing when we have regarding seriousness? We are focused on the violation. Yes, I think this would go along with the second part of the hearing better, actually. That's
Okay,
my,
okay.
So right now, we're looking at the one charge that we have. Is there anything you guys want to say just regards to that one charge?
Yes,
Okay.
I'll interject at this point. So I think the question is whether or not Charles violated this term of parole, right? Whether he possessed firearms, ammunition, or any other weapons. And frankly, I think the answer is no, he did not violate. He didn't have any guns. There's been no evidence of that. There's no evidence of ammo, and he didn't have any weapons. And now I know that, Supervisor Mann has said that we concede at this point. I disagree. And I want to be clear and distinguish between the two issues here. Are these knives? Yes, but that by itself does not make it a weapon, right? Having a knife is not enough to violate his term of special parole. I mean, he's allowed to use steak knives to eat. He's allowed to use knives to cook with. He hasn't been violated for that. And so I would urge you to consider, like, what makes it a weapon, right? And this goes to the point that I raised earlier in the preliminary hearing. Where is the intent to harm? A weapon by its plain definition is an item that's used to cause injury, that's used to inflict harm on other people. And we don't have that intent here, right? All the evidence that we have submitted on behalf of Charles shows that he had no intent to use any of these knives to harm anyone. He's a collector. And Eric is going, my colleague Eric is going to speak more about, Charles and who he is and what his family situation is like. But he is an artistic individual who collects these valuable items for collectible purposes. We've submitted a lot of images to you to consider, and these are images that I don't think you saw the first time around or in the state's evidence, but they are images of objectively beautiful knives. They are expensive. They were in his storage unit. So, for example, we can take a look at the Defense Exhibit 30 and 31. I mean, this is the mother of pearl angel wing knife. It's purple. It has mother of pearls on it. It's worth $2,300. All right. We have Defense Exhibit 23 to 24. That's a mammoth Gotsis engraved knife. It's made out of mammoth ivory. That alone is worth $1,200. DX18, which is the Jan Hafnick knife. It's shaped like an artifact. It has curved edges. This is not an item that you would use to commit harm. Same thing for DX35. It has a purple colored handle. It's objectively beautiful. And we have that, a note from a seller, DX Defense Exhibit 36. The seller agrees that this is a stunning object. And we put in all of this information and we put in photos of how these knives were cataloged and stored. I mean, first of all, these knives are carefully wrapped. They're wrapped in towel and sheets. They're then packaged in envelopes. They're marked, they're cataloged with the name, the price. They have photos of what, of their value, and they're cataloged in a storage container that's then away in a storage container and locker. I mean, this is how you would package and store expensive items that you cherish. It's not something that you would use to cause harm or mass destruction. And I think that's an unfair characterization of what's going on here. And I would say another point about why, there's no evidence that Charles intends to harm anyone is just look at his history, right? Yes. Did he serve time for a felony conviction? Yes, but he served over 10 years on that, all right? And he was sentenced to maximum or medium security prisons, and there's not been a single allegation of any violence, any harm caused to others, and he's in jail. And this is for over 10 years. Then he's out on special parole, which we all know contains very stringent conditions. He's heavily monitored by the state, and he's heavily monitored by Hopkins. He is on constant surveillance 24/7. They follow him to doctor's appointment. He takes care of his mother. They follow her. I mean, it's nonstop. And this is the first time we're appearing here before you on a parole violation. And I think we can all understand the significance of that. For someone to be on such close supervision for so long, it's rare to have that compliance. So again, I think this is important because, if the narrative is that he is so dangerous, that he's such a danger to society, that he's using these items as weapons to cause harm, the facts do not support that narrative. And I think it's important to also recognize that his prior parole officer, Erica Richardson, actually recommended that his term of special parole be terminated early. And but for Hopkins, he probably would have gotten that. And I want to also just quickly touch on, the exhibits and supplemental exhibits that the state has submitted. And I want to focus on their Exhibit E, which is the law enforcement report that actually prompted the search of the storage unit. All right. If you read through that report, there are inaccuracies in there and misrepresentations that, again, go towards framing Charles as this unstable individual that, again, is not supported by the facts. Hopkins apparently told law enforcement that they saw Charles going into a storage locker with latex gloves and an ammo can. To date, there has been no evidence of that. None. There's no latex gloves. There's no ammo can. And in that report, it says Hopkins saw him come out of that storage unit without an ammo can. There's been nothing. There's been no physical evidence of that sort. And in fact, we've submitted the opposite. We've submitted DX 4 and 5 that shows that these latex gloves are blue mittens and that any ammo can is a Home Depot, is a type that you could buy at a Home Depot. It's a field box that can contain anything. And I would also object to a reference in there that I think calls Charles unstable based on prior, psychological exams or evaluations. There's been no record of that. None. Because he has not submitted to any mental health exam by the state. All right. So that, again, I think is an incorrect and inaccurate misrepresentation of who he is, which has brought us here today. I also, and also, on that point, Charles isn't someone who is not monitored. If there's been any allegation that he has exhibited unstable behavior at any point in his parole, we would have heard about it and you would have heard about it, but we haven't. And none of the evidence that, the state has submitted undermines the fact that he is not intending to harm anyone. First of all, searching for information online is not a crime. All right, he's entitled to know who's involved in his case, who has provided adverse information. It's just not a crime. There's been no threats, there's been no confrontation and no acts of violence that anyone can point to. And the same thing goes for the electronic monitoring. I understand the state's inference here. I understand what they are trying to argue, that he is somewhere that he should not be. But for every negative inference, there's a perfectly innocent explanation. You cannot tell me that GPS exhibit has any explanation. It's all speculation. He could be driving, he could be walking, he could be there to get a sandwich at a sandwich shop. There's a park there, there's a cemetery there. We have no idea. And I think it is unfair for the state to suggest that he is there for a negative purpose when there has been nothing on the record explaining why he was there, what he was doing, because you know what? No one ever asked him. And I think so, those are my main points against the actual evidence on the parole, on the alleged parole violation. Frankly, I don't think there is a violation. These are not weapons. There is no intent to harm. And I'll defer to my colleague to talk more about the history of the case, because I think that's really important. This is not a standard, revocation proceeding involving someone, who has no history or has a standard history here. This is there's a complex background. Charles has been subjected to custody and also to a supervision that I don't think anyone has seen in the state of Connecticut, much less the US. Like, I've never seen a situation where he is monitored by parole on stringent conditions and then followed by private security over the course of 10 years.
I would
Great.
definitively like to respond.
All right, council, are you done with this portion at this time?
Eric, do you have anything to add?
No.
All right, so I'm gonna turn it over to the state then if you'd like to reply.
Absolutely. So let's start with the first point, which was I appreciate council's subjective opinion that these knives are not dangerous, and that is great. They might be very valuable and beautiful subjectively, but I would like to deal in facts, and the facts are that objectively, the state statute 53-206, and I just want to read a part of that, because there's a part of that statute which clearly defines, enumerates what is considered a dangerous weapon. These weapons are a slingshot, an air rifle, a BB gun, blackjack, sandbag, metal or brass knuckles, dirk knife, switchblade, or other knives having an automatic spring release device by a blade that is released from the handle, having a blade of over 1.5 inches in length, a stiletto, other knife with an edge portion of the blade over 4 inches in length. So the objective fact is that Mr. Cornelius, and the defense has basically made our point for us, that he bought these knives. They are considered dangerous weapons under Connecticut statute. Therefore, his violation of I will not use or have in my possession or control any firearms, ammunition, or any other weapons, there is no question that that is a clear violation of that. So I understand the subjective opinion that these are beautiful pieces of art, but the fact is that they are under Connecticut's state statutes. They are also considered weapons. I would also like to get into the last point that council made regarding, and I was going to get into this a little bit later, but regarding the evidence that we have submitted that shows that not only did, and listen, defense is right. It is not illegal to take screenshots of personal information that is publicly available online. And that is what we found in Mr. Cornelius's phone. However, it should be noted that those personal information was related to people who Mr. Cornelius appears to feel have somehow harmed him or have been involved in his case. That goes directly to his underlying charges, of which he is serving a long incarceration and special parole period. I think that needs to really be, if you want to talk about the totality of the case, let's talk about that the exact same behaviors, just about, in which he received a extremely lengthy sentence, is also being played out right here in real time. So on his phone, what did we find? What we found are screenshots of personal and private information that of home addresses of Board of Pardons and Paroles employees, Parole and Community Service employees, and this is what is perhaps the most disturbing to us. He also had screenshots of a previous parole officer's daughter's address. And I'm going to also put this on the record as well. This is very, very important. Not only were there screenshots of the actual address, there were screenshots of a Google Street View of that daughter's workplace. That is extremely disturbing to the state. Now, again, these are just screenshots, and you might say to yourself, well, he's just taking screenshots. Then, on 3 occasions, I will give you the dates right now. On February 8, 2024 at 2:27, on March 20th, 2024 at 1:25 p.m., and on May 23rd, 2024 at 1:28 p.m., Mr. Cornelius went to one of those addresses of a Board of Pardons and Parole employee that he had screenshotted. Counsel has noted that, well, there's a park around there, that he could be doing anything. And if you would like, I can share my screen and we can look at the actual map of where this address is. This is a deep in a residential neighborhood. Not only that, but this is a one-way street on a cul-de-sac. And on that cul-de-sac is only 5 or 6 residences. One of those residences happened to be the address of that Board of Pardons and Parole employee. I will contest that there is absolutely no reason why an individual would happen to be at that exact address. This is not an address that is on a main thoroughfare. You have to go way out of your way to get to this address. It's down a one-way street on a cul-de-sac. He was there on 3 different occasions. So again, let's look at this, and I think the other attorney is going to talk about, you know, the totality of this case and how Mr. Cornelius has, you know, been a victim in all of this. The totality of the case is that Mr. Cornelius has a long history of becoming fixated on individuals who he believes have done him wrong in some way. We have now provided evidence to the Board of Pardons and Parole that shows that perhaps those behaviors are continuing. And that is why it would be an egregious mistake to allow Mr. Cornelius to an early release from this revocation before his end of sentence.
Okay, so counsel, you can either respond now, or we can also, we're going to get a chance to talk about the seriousness of this after the first part of the hearing.
I would just like my colleague Christina Gotsis to respond to, we'll respond to the other points as well, but to the issue of Connecticut General Statute 53206, I do believe that Supervisor Mann has overinflated the statute per its specific language, but I'll let Christina defend this point.
Hello, hearing examiner Meisinger. I just want to point out, as has been characteristic of the evidence and the testimony we feel has been introduced by the state against Mr. Cornelius, that there are important facts that are being left out and or mischaracterized. So Parole Supervisor Mann has referred to statute 53206 and has purported to read a definition to you of what is a dangerous weapon. I do want to read to you that the title of the statute is "The Carrying of Dangerous Weapons Prohibited," and the actual language says that any person who carries upon his or her person, and then it goes into this definition: BB gun, blackjack, metal, or brass knuckles, as Officer Mann said. So I do want to say that the statute he's explicitly referring to and citing to as a parole violation and Mr. Cornelius having in his possession or control is not actually applicable here, because this statute only prohibits the carrying of these dangerous weapons on the person.
I would like to respond to that.
Go ahead.
The fact that you cannot extrapolate what the state deems as a dangerous weapon because we did not happen to find that these weapons he was carrying, I think it's not reasonable to understand that the definition of what the state of Connecticut deems to be a dangerous weapon is somehow thrown out because he didn't meet the criteria of this one statute. I think that's unbelievably unreasonable. And the fact is that the state obviously has defined what they believe a dangerous weapon is, whether it was found on his person or not. We have provided evidence, and defense has admitted that he was in possession of this. So that is muddying the waters, if you will. The definition is the definition.
I don't need to extrapolate.
Well, Christina, I don't want to go into tit and tat because, like, we're now arguing over the application of a legal statute, which, you know, Charles has not been accused of violating, nor
Correct.
do we believe he has violated. I think the point is that, you know, there was if I recall correctly, there was an indication that he did violate the statute, and he did not. He did not violate the statute because he did not have these items on him. And I think that goes back to the issue of, did he have intent to harm? No. He did not. These items were packed in a storage unit. And I do, you know, look, if we want to get into a legal discussion as to what, you know, what the statute defines as a deadly weapon, we're happy to submit briefing on this. But I don't think that's the point here.
Thank you. All right. So is there any other comments before I announce my findings with respect to the charge?
No.
Okay. All right. So I'll be right with you with my findings. So regarding that charge number 1, I do find you violated that condition, obey all laws, weapons. This is based on evidence as well as testimony provided in support of the charge, which we have exhibits A as well as E through I. They do meet the elements of violation for the Board of Pardons and Parole regarding that charge. So that includes the fact-finding portion of the hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, counsel will have the same opportunity. The purpose part of this hearing is to help determine what outcome I will recommend. So, P.S. Mann, at this time, would you like to say anything regarding the second part of the hearing?
I think that I have covered a lot of it. Again, I will go back to counsel's defense that there is no evidence that Mr. Cornelius ever intended to use or that these knives. And the facts of the case are that we don't know that. It is highly suspicious that Mr. Cornelius went to the address of a Board of Pardons and Parole employee on 3 separate occasions, not once, not twice, but on 3 separate occasions. I have already spoken about how it is unreasonable to believe that this was just coincidence, that he happened to be in the area. This was not a town, anywhere near a town that he lived. And what the GPS actually shows is he specifically went down there, he went to this address, and then he went back to his hometown, to his home. he was not engaging in other activities. It is clear from the evidence that we have that he went to this address with a certain purpose. And again, I want to bring up the totality of this case, which this is ominous that he this is based upon his original type of offense, which is extremely disturbing. I also want to again bring up the fact that not only did he have in his phone personal information about individuals who may or may not have testified against him, have written reports that he deems were against him, but the child of one of those members. That is, being a father myself, that is extremely disturbing. And so, again, it is on the record, it is no secret that Mr. Cornelius has his end of sentence very soon, relatively, in May. The state would definitively ask for a complete revocation of the rest of Mr. Cornelius's parole, given all of those facts. And I reserve the right to comment after we hear from counsel.
All right, counsel, if you'd like to speak at this time.
Yes, thank you very much, and I appreciate it. Okay, so I'd like to talk a little bit about Charles Cornelius and talk about the good person that he is, and how he's really made enormous progress over the last 8.5 years since he's been out on special parole. Charles is the sole caretaker of his 83-year-old mother. He drives her wherever she needs to go. He takes her to medical appointments, grocery shopping. He helps out with the handy man work in the house. He basically does everything to make his mother's life easier. While he's been in prison, he calls his mother at least twice a day to just make sure that she's okay. And you know, as you may know, his father passed away while he was in prison, and that hurt him very, very much, that he couldn't spend his last days with his father. And so I just want to point that out, that he's got great love for his mother, and his mother misses him, and she's worried about him, and he's worried about her. Okay. Now, something else that might surprise you, but every Passover, Rosh Hashanah, Hanukkah, okay, who do I get a card from? Not every single time. Charles Cornelius. He's the only person that I can depend on who will send me a card for those holidays. We discuss books. We discuss philosophy. We discuss the justice system. Charles is a complicated individual, and the key here, and what I'm going to ask you to do, hearing officer, is to basically not choose revocation, but choose therapy and oversight to over this last month and a half to honor the parole's promise of rehabilitation, which is what parole is all about. It's not about punishment. Charles here may have slipped by ordering, by collecting these knives, but and he may have slipped in it. Well, let me go on. Let me actually talk about this, because the history of Charles in jail. Okay, he's been in some of Connecticut's high security prisons and medium security prisons. He spent and a half years in prison. He spent 14 and a half years in prison. The first 10 and a half years, the first 13 and a half years, or 13 years were in Connecticut state prisons. And then he spent another year and a half in federal prison. Okay. He has one infraction, which was having a hot water heater in his cell. That was basic. That is it. There was never any violence, threats, no gang, no proselytizing of hate speech or anything like that he's been portrayed as some sort of monster, some sort of future Adam Lanza. If we only, we basically, Hopkins takes credit for basically stopping something that they invented in their own, on their own. There's just no basis to think that Charles Cornelius is a dangerous person. Okay. And there was one psychiatric evaluation of Charles Cornelius, and that was provided at sentencing. And it was by Dr. Mark Mills, who evaluated him with the MMPI-2 and PEAI tests. These are rigorous scientific tests, and concluded there was no evidence of violent tendencies and a low likelihood of future harm. And Judge Blue characterized Charles as someone who needed to be warehoused, who basically was going to blow up a building and so forth, because he branded him a racist and someone who was basically stockpiling weapons. At the end of the day, who proved to be right but Dr. Mills, the psychiatrist who examined Charles. The fact of the matter is that while on the 8.5 years while out on special parole, he's had a verbal warning. This is his first infraction on special parole. And the idea here is that we want him to transition to the community. We don't want to I think that he's been in jail already for almost 3 months. Isn't that enough? Why don't we use this month and a half to try to have Charles go to therapy? Okay, and the therapy that I'm going to recommend is that he at his own on his own expense hire a therapist who will see twice a week. Okay, and the Board of Paroles is entitled to find out one thing: is he a danger to himself or to others? And that's really the point here. That's what we really need to do. We should encourage Mr. Cornelius. We should encourage Mr. Cornelius to deal with certain things, deal with the stress, deal with his trauma in a way that is constructive. And I think that we can all agree with that, because look, the board of Paroles, we have documents that show that the Board of Paroles was actually said that we don't think Mr. Cornelius should be surveilled 24/7 by Markle Investigations, which was hired by Hopkins. We don't think he needs to be surveilled the entire time. And the Board of Paroles rightly allowed him to live with his mother against Hopkins' wishes. And I think that today the Board of Paroles should do the right thing and stand up and try to get Mr. Cornelius to ease his transition to the community. So let me go into the specific charges here. The knives. Let's talk about the knives. Okay, there was. I can see the concern that they're knives. But they aren't tools of harm. They're a passion. They were kept in their original packaging in a storage locker. This isn't a stock pile. This is an interest that he has, and it fits a man drawn to craftsmanship, not conflict. He's never wielded a weapon against anybody. And so going to the searches, the internet searches and the drives that showing him near the homes of people who are affiliated with the board, it's easy to misread, but this isn't menace here. It's a response to relentless pressure. Since starting parole, 8.5 special parole, at least outside of federal prison, 8.5 years ago, he noticed surveillance. There were cars trailing him, people walking behind him. I remember getting a call from Mr. Cornelius telling me, Eric, there's people following me. I know that there's people trailing me. And I thought that Charles was simply paranoid. And I said, you know, that can't be true. But in fact, the first parole officer that he had actually assured him, no, that you know who that is? That's the FBI that's watching you, and agree to a psychiatric evaluation or they'll arrest you. Okay, that was a lie, and it was a lie that special parole officer knew was a lie. It was a tactic to force an unnecessary evaluation. The reality was that it was private investigators hired by Hopkins to shadow him day and night. And the parole board met with the Hopkins officials who labeled Charles a danger to the community and their school. And you guys advised them that round-the-clock surveillance wasn't needed and it might set him off. It did. I mean, he felt the eyes, the weight of this surveillance, and it rattled him. And when he challenged this surveillance, not by violence, when he challenged it in court, the response was, look, the law permits you to be surveilled so long as they're not looking into private spaces, right? And so long as it's in the public gaze. So Charles has been followed around, in addition to his GPS, he's been followed around by Hopkins for many years at this point. And why? The question is why? Why is he a threat to Hopkins? Why does Hopkins write to the parole board in August of 2024 and say that they're a victim of Mr. Cornelius's offense? They're not a victim. They're not a victim. There is no victim of Mr. Cornelius's offense. He collected a number of weapons, illegal weapons, and therefore he served time. He was convicted of a crime. Should he have served this much time? No. He's been deprived. It's 24 years of his life, 14.5 years in prison, and then 8.5 years on special parole under strict supervision. And we can see that he's made progress over time. And I'm sure, as the Board of Paroles is well aware, people sometimes slip up during these kinds of periods. And what was going on here? What was going on here is hypervigilance, which is psychology. It's a psychological concept. It's 24 years of scrutiny, like here, would make you hyper aware, scanning for the next move against you. You know, he's looked up board members. He clearly didn't confront anybody. He didn't threaten anybody, right? No one was threatened. No one was confronted. This is what we're talking about. He's trying to understand the case. He's surviving. He's trying to respond to a system that's hounded him for many, many years. He's a man pushed to his limits. So what's the right path, right? Revocation now, after 3 months locked up since Christmas. It ignores his records for Hopkins' panic. He's not a shooter, okay? And Dr. Mills's 2004 evaluation has proven true across 24 years. Judge Blue's fears have never materialized, okay? There's no intent here to harm anybody. There's no intent here to threaten anybody. And the revocation of his parole would tear apart for another month and a half his mother's sole lifeline, and her well-being and stability depends on Charles being around the house. Why don't we have him go into therapy and address these issues so that he can better deal with these triggers? Okay. The fact of the matter is that every single time that Charles has been, he can't be examined. Every time he's reached out for help, every time he's wanted help, he's been concerned, and rightly so, that the psychiatrists from the state are simply are basically out to portray him as a active shooter and to lie to him, to get him to talk to them. There was David Rentler who visited Mr. Cornelius in prison and through a ruse tried to examine him. And then there was his first special parole officer who lied to him in order to try to get him to go to see a psychiatrist. The fact of the matter is that private therapy, twice weekly, funded by him, no state involvement, okay? The therapist will report danger, and that would be that. He can have his GPS monitoring, and he's learned his lesson. He's been punished for it, for his violations, right? He served 3 months in prison. 6 weeks is our window here to transition him from home to his mother, to freedom, to fulfilling Parole's goal of rehabilitation. Hopkins' fear has dictated his life for too long, and let's not steal these. Don't let it steal these final steps for him to be able to transition to the community. You know, Mr. Cornelius, like all of us, he's not flawless. His views draw scrutiny in the mind of the Board of Paroles. His knives crossed the line. The searches stirred concern, but he's not a shooter. He's not a danger to the community. He's a man who's endured. He's endured, some significant punishment for 24 years now. Okay, and Dr. Mills described him as low risk. What Hopkins saw was a myth. Okay, they created a myth of someone who's an active shooter. He's not an active shooter. He's not nearly an active shooter. There was never any violence or threats towards Hopkins. They have somehow turned themselves into the victims here, and they're not victims. And I don't see how the Board of Parole could consider them victims. Okay, revocation would bow to their fear. But it's not the reality. Therapy and oversight can guide him home to his mother, to a fresh start. I think he's earned that chance. And please don't let Hopkins' shadow take it away. And that's, I think that covers what I'd like to say. But I also reserve the time to respond to the state.
Can I respond?
Sure, go ahead.
Okay. Number one, let's sort of put this on the table regarding Hopkins School. The state Parole and Community Services has nothing to do with the Hopkins School. And we are bringing these charges and we are making the recommendation of a full revocation of parole based upon the evidence that we have gathered and have acquired. We have nothing to do with Hopkins School, and this is based upon our own evidence. Whatever Hopkins School does is what Hopkins School does. This is simply from the state. I find it very interesting that council, on one hand, calls our previous attempts to get mental health treatment for Mr. Cornelius a, quote, unnecessary psych eval, and citing another psych eval that was conducted that shows that Mr. Cornelius, has no issues, yet they argue that the exact reason why we should allow him to be released early is because he needs mental health and he needs to go to treatment. And the reason why he is going to Board of Paroles members or staff members' addresses is due to mental illness and some complications due to mental health. We really don't think that you can have it both ways. And so therefore, if Mr. Cornelius after May would like to seek mental health treatment, then I think that's a great idea. But in regards to these violations, I think council referred to it as a slip up. In Parole's world and what we do every single day, a slip up is using alcohol on one occasion. That's a slip up, and for that we issue a misconduct, and we don't violate parole normally. This goes well beyond that type of quote unquote slip up. The looking up both staff at the Board of Parole and Parole and Community Services, going to their addresses, looking up the children of those individuals, and having a what can only be described as a cache of deadly weapons. It goes well beyond a quote-unquote slip-up. I agree that not everybody is flawless, as counsel just said. However, many people are perceived by individuals as having harm done to them by other people. Most individuals do not look up those people's children's and the street view of the addresses of which they work, nor do they go to the addresses of those individuals. So yes, not everybody is flawless, but I think that this goes well above and beyond. That's all.
Yeah, if I may respond to Supervisor Mann's points. Look, I understand how the supervisor is looking at this, but again, this is clearly the supervisor can't point to any violence because there was no violence. He can't point to any threats because there is no threats. And he can't point to any intent to do anything because nothing was done. The fact of the matter is that I'm not suggesting he has mental illness. I don't think Mr. Cornelius has mental illness. I don't think a psychiatric evaluation is necessary, but I think that he could benefit from therapy. And I think that the idea of someone, for Mr. Cornelius, who went through 14 and a half years of prison with a single, the most minor infraction you can imagine, okay, if someone is as dangerous as Mr. Cornelius is supposed to be, right, for him not to have not a single incident of violence, not a single incident of being involved in any sort of gang, not anything. Okay, he had a spotless record for 14 and a half years in prison. 14 and a half years. Most people don't get 14 and a half years for a non-violent offense, which is what Mr. Cornelius's offense was. And then for the 8.5 years on special parole, his record was spotless as well. I mean, so we're talking about here what is odd. What I don't think that there's any evidence that goes beyond that Mr. Cornelius was collecting these knives. Now that clearly, according to the Board of Paroles, that violates the conditions of his parole, and we have to accept that. But the question is he was just put in jail for 3 months. And the question is do we want the next month and a half for him just to be sitting in jail and to threaten to damage the rehabilitation that he clearly has made and has shown? or can't we deal with this constructively? That is what I'm asking the Board of Paroles to do. I think that Mr. Cornelius has earned that chance. You know, he's had great experiences with his last two parole officers, including his current parole officer and the parole officer before that. And he's been gradually, the degree of supervision has gone down to minimal supervision. And, you know, look, if we think, why don't we increase the level of supervision for the last month and a half? Okay, but let him out. Let's let him transition into the community in a way where we can build on his progress, where we can build on and basically address and basically have him address to, you know, go to therapy and deal with his issues in a more constructive way. And I think that he can. And I know that he can because I know Mr. Cornelius and I know his mother and I know the kind of person that Mr. Cornelius is. He's resilient, but a lot of people, I mean, I don't know too many people who have spent this much time in prison and then following that, a special parole for such a long time. And look how well he's done under it. He really has done very well. And for it to end this way, with him in jail, I think sends the wrong message. I think Mr. Cornelius has demonstrated that he can follow orders, that he can, that he has a lot of promise in him. He is artistic. He can do things. He can take care of his mother. This is something that that should be considered by the Board of Paroles in making a decision here. I really urge the Board of Paroles to let him be released. We can have it under moderate supervision at this point, and let him do what I'm asking that we do. That at his expense, he will seek therapy twice a week, and the therapist can report to the Board of Paroles if there's any concerns that the therapist has, and that's what I'm asking for.
Just,
and I
very,
thank you.
Thank you.
Just very, very quickly. Council is correct that part of parole and community services is rehabilitation. It's a huge part of our mission statement and our mission in general. Beyond that, though, is our obligation to protect the public and protect the victims in all of our cases. And we have found enough evidence that we believe that protecting of the public goes beyond any type of rehabilitation that could be provided to Mr. Cornelius at this time. And therefore, that is why we ask for a complete revocation of his parole.
And if I could just say one thing, I don't want to, you know, it doesn't need to keep going back and forth, but I just wanted to make one point. Is again that there's no sign that until until there was some that Mr. Cornelius has been followed, he's been surveilled, and no one has noticed anything out of order here. I mean, Mr. Cornelius is not a danger to the community. He simply isn't, and there's no evidence of him being a danger. And so why don't we just end this on this term of special parole on a note where he's being helped where there's some assistance, where there's some guidance by the Board of Paroles to help him transition back instead of having to spend another month and a half locked up in the jail. That's all I have to say.
Thank you. All right. So is there any additional information that we have not discussed yet that either side would like to say at this time before I make a recommendation?
Well, all I could say, if there's some issue that I could address, I'd be happy to, because I have lived this case and know the history of Mr. Cornelius's case for the last 14 years. And so to the extent that I can address any points that the Board of Paroles is concerned about, I'm happy to do so.
I just want to clarify, so he would like to go back to his mother's, that's where he would be returning to?
Yes.
Okay, so that would be his plan. Okay. In regards to, I know we discussed a lot about, we talked about public safety, we talked about, each side has got to say their point on things. Is there anything additional from either side in regards to like release plan? That we did not say yet?
No, not
Okay.
for me. Thank you.
Okay, so I'm gonna take a minute and I'm gonna be right with you guys with my recommendation.
Waters.
So I do want to put on the record, I have listened to testimony on behalf of the state as well as council today on behalf of Mr. Cornelius. I will put on the record, he was on supervision for about 9 years and 7 months before returning to custody for this, his first violation of parole, which is why we're here today. He did receive one misconduct in 2017. The state is recommending full revoke of the offender's supervision. He does complete supervision May 17th, 2025. As was noted by testimony today, it is concerning that this is some of the similar behavior that was why the offender was on parole, which includes having a large amount of weapons. As was noted by counsel, he has done well previously while on supervision for the amount of time he has been out. Based on the information that I have, as well as all testimony that I have listened to today, I am going to recommend that parole be revoked and that the offender remain incarcerated until his special parole completion date of May 17, 2025. This is an approximate 4.5 month sanction. My findings are going to go to the parole board on March 27th. The parole board has the opportunity, as I only make recommendations, the parole board makes the final decision. So on March 27th, the board is going to make the decision on whether or not they can agree with my sanction or they can let the offender out earlier. The earliest he can be let out is March 27th. They can let him out that day or any time in between the date of his end of special parole, which is May 17th. So he will receive this in writing from the parole board, what their decision is. About a week after March 27th, it will be mailed to him what the board's final decision is and if he will be given special parole conditions if he is re-paroled. So he does have that definitely could happen. Do you guys have any questions or clarification?
Is there an opportunity to appear before the board before they make their final determination?
No, no. So the board will make that decision, as I said, on March 27th, and he will get it in writing what the decision is.
If I may, what information would be presented to the board? Is it just the finding, or do they get a recording of the audio?
Well, they're going to get a write-up of the summary, everything that you guys receive. They will get the summary of today's hearing, and then that's what they will be looking at. So if there's no further questions, this revocation hearing is concluded. So Mr. Cornelius, you're going to get something in writing from the board. Okay, you get their final decision March 27th, a couple of days after that, probably.
Thank you, hearing officer. Thank you.
Thank you all.
Supervisor Mann.
Thank you.
Thank
I
you.
appreciate you guys.
Thanks.
Have a good day, everybody.
You too.
Thank you.
We'll put on the record inmate Aaron Velez, number 292593's preliminary hearing has been continued to March 31st. Morning.
Good morning. How are you?
Good, how are you?
Good.
Good morning. Sorry, you're muted.
Morning.
Good morning. I just have
Give me a
Mr.
call.
Hooks.
Yes, he'll be in here momentarily.
Great, thank you.
Yep.
And I know we're not on the record yet, but it is going to be a waiver.
Okay.
Yeah, I was just a little delayed in being able to speak with him, but I spoke with him shortly before the hearing.
Okay, no problem. I'll just introduce school on the record and then.
Perfect. Thank you.
Good morning. Mr.
Morning.
Hooks?
Yes.
Good morning. So I have your
morning.
attorney here. I'm just gonna go on the record. I know you spoke to your attorney before. Okay? Good morning. I am P.O. Meister, hearing examiner for the Board of Pardons and Paroles. Preliminary hearing, concerning Hooks Melvin, number 323721, says March 19th, 2025. This hearing is being conducted via video at the BOPP Central Office in Corrigan Correctional Center. This is a public hearing. Public access to the hearing is available via video live stream. Can you just state for me your full name and DOC inmate number?
Melvin Hooks, 323-721.
And you have counsel here?
Yes, for the record, Hannah Dean on behalf of Mr. Hooks.
And you put in a request. You said you'd like to waive, is that correct?
Yes, at this time, we are asking to waive the preliminary hearing. I know it's just a one count criminal violation, so we would like to waive it this time, and I will update once there is a disposition in criminal court.
Okay, so I'll accept the waiver of the preliminary hearing. Mr. Hooks, then we will see you upon disposition of those charges. We'll bring you back to determine if there's a violation, okay?
Okay.
Okay, so you're all set for today.
All right. Thank you.
Thank
All
you.
right. Talk to you soon, Mr. Hooks. Thank you. All
All right. Thanks.
right, I'll see you back at 11.
Thank you. Good morning. So you're muted, York.
Can you hear me now?
I can hear you.
Okay,
Perfect, thank you.
you're welcome.
Good morning, P.O. Chan.
Good morning.
Good morning, Ms.
How are you?
Castro.
Hi, Miss Castro.
Hi, how are you?
Good. How are you?
Hanging in there.
Good.
Mm-hmm.
Pushed it earlier, and then sometime, I think because we left and then.
All right, we're here today for your revocation hearing. So we are going to get started with. You asked that? Are you ready? Good morning, I am P.O. Meister, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Castro Meiling, number 437864. Today's March 19th, 2025. This hearing is being conducted via video at the BOPP Central Office, New York Correctional Institution. This is a public hearing and public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Meiling Castro 437864.
We have parole officer present today. Please identify yourself for the record.
Parole Officer Sheehan, Women's Reentry Unit, New Haven.
Thank you. We have counsel here today. Please identify yourself for the record.
Thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Ms. Castro.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence. That is, the better weighted evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation or one or more conditions of your parole, I will reinstate your parole, which is releasing and placing back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make recommendation as to appropriate sanction, and my recommendation be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we're going to review the parole violation charge, state your PO is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present a relevant testimony. After the state is finished, counsel will have the same opportunity. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, counsel will have the same opportunity. Do you have any questions about the purpose or procedure?
No.
Okay, important rights today. You have to have an attorney present and you have counsel here. You have a right to see the written notice to charge the violation. Did you receive the written notice?
Yes.
You have a right to review the evidence against you. You have a right to submit evidence for your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
All right, so now review the charge, the state your PO is bringing against you and the information underlying each charge. So PO Sheehan, please read the charges.
Sure. Charge 1 under curfew on 1/9/2025 at approximately 6:18 p.m. You walked out of Rise Halfway House and stated you were leaving the facility and not coming back to the program. You did not have permission from the halfway house or your parole officer to leave the facility. Your whereabouts in the community were unknown and you refused to disclose where you were to staff. This is a violation of Board of Pardons and Parole's release direction. Charge number 2, drug testing on 9/10/2024 or about this date, you rendered a urine sample positive for marijuana and fentanyl while at Rise Halfway House program. Based on your actions, you are in violation of release direction, obey all laws. On 10/15/2024 or about this date, you rendered a urine positive for marijuana and fentanyl while at Rise Halfway House program. Based on this action, you're in violation of release direction, obey all laws. Number 2, obey all laws. Charge number 3, obedience to the law. On 9/10/2024, you rendered a urine positive for marijuana and fentanyl. On 10/25/2024, you rendered a urine positive for marijuana and fentanyl. On 1/10/2025, you assaulted the case manager at Rise Halfway House while residing there. You were arrested on that day and charged with 53A182 disorderly conduct, case number 25-000-13407. Connecticut State Police gave you a summons with the arraignment date of 1/13/2025, and you were turned over to parole and remanded to York. That is a violation of the Board and Pardon Paroles, obey all laws. Charge 4, halfway house placement on 1/9/2025 at approximately 6:10 p.m. You walked out of the Rise Halfway House and stated that you were leaving the facility and not coming back to the program. You did not have permission from the halfway house staff or your parole officer to leave the facility. Your whereabouts in the community were unknown and you refused to disclose where you were to staff. On 1/10/2025, you assaulted the case manager at Rise Halfway House while you resided there. You were arrested on that day and charged with disorderly conduct. Connecticut State Police gave you a summons with an arraignment date of 1/13/2025. You were turned over to parole and remanded to your correctional.
Did you read the charge of drugs number 3?
Obey all laws, number 3.
Obedience to law and then obedience to law is charge 2. Charge 3, drugs.
You know what? I think she was served twice, so you may be correct that it did get updated.
Yes, it did.
So charge 2, obedience to the law is drugs. So 9/10/2024, on or about that date you
Charge
rendered a
2 is
urine.
obedience to the law, and then you have a separate charge 3, drugs charges, which I have as the current one.
Okay,
Correct?
that is the current one, correct, yes. You want me to read charge 3, drugs?
Yes, please.
On 9/10/2024 or about the date you rendered a urine positive for marijuana and fentanyl while at Rise Halfway House program. Based on this, your actions are in violation of release direction, obey all laws. On 10/15/2024, on or about this date, you rendered a urine positive for marijuana and fentanyl while at Rise Halfway House program. Based on your actions, you are in violation of release direction, obey all laws.
Thank you. And
It
the
was
state is filed above. What was
I'm
that?
sorry, it was a fax copy that, and it's almost illegible. Sorry about
Yeah,
that.
no, it is hard to read. I understood, and you're right, with what you just read, so. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, signed statement understanding agreement, conditions of discretionary parole. B, Connecticut Board of Parole remand to custody order. C, notice of parole violation. D, parole violation report. E, notice of parolee rights. F, Rise Women's Program Halfway House Agreement. G, Rise Women's Program Residential Handbook, Acknowledgement and Handbook. G, Rise Women's Program, what I just said. H, Rise Program Incident Report for positive toxicology screening. I, Quest Diagnostic Drug Monitoring Report for positive fentanyl use collected 9/10/24. J, Misconduct for positive drug screen dated 9/18/24. K, Rise Program Incident Report for positive toxicology screening dated 10/22/24. L, Quest Diagnostic Drug Monitoring Report for positive fentanyl use collected 10/15/24. M, Voluntary Admission for positive drug screen dated 10/22/24. And Rise Program Incident Report for escape unaccountability dated 1/9/25. O, Rise Program Incident Report for assault on staff dated 1/10/25. P, misdemeanor summons premise appear bail dated 1/10/25. We'll put on the record exhibits Q and R were not, we were unable to view that, so that evidence has not been received and is not considered at today's hearing. Did you receive notice of parole violation report, and those other documents I marked? And did you review those?
Yes, ma'am.
And council's file the following exhibit pre-marked for identification purposes. That's Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No.
Okay, we have no witnesses. So at this time, the state is going to have an opportunity to call witnesses, present evidence, speak to any of the evidence submitted. I'm going to swear in P.O. Sheen as well as Ms. Castro in the event that you do want to speak today. Can you both please raise your right hand? You solemnly swear or solemnly affirm as the case and be the evidence you shall give, turn this case to be the truth, the whole truth, and nothing but the truth, so help you God, without penalty of perjury?
Yes, ma'am.
All right,
Yes.
so P.O. Sheen, would you like to say anything in regards to the violation?
I'm concerned that you didn't get an opportunity to see the the video. I was able to observe the video, and I was able to observe Miss Castro assaulting and hitting the staff member at the halfway house. So because you don't have the video, I wanted just to make it clear that I was able to observe it.
I know it's true.
Ms. Castro, please don't make any
And
comments.
I apologize for that.
Ms. Castro,
Yes?
please don't make any comments. Please do not comment.
No problem.
Go ahead, P.O. Sheen.
I just wanted to, because you weren't able to view the video, I wanted to make a statement that I did see the video.
Anything else you'd like to say, P.O. Sheen, in regards to the charges?
No, I think they speak for themselves other than that.
All right, turn over to council.
Thank you. No comment as to charge 1 curfew. In regards to charge 2, under the obedience to the law, just referencing paragraphs 9/10/24 and 10/15/24, we would submit there's insufficient evidence to support that charge, as the charge requires that the parolee was engaged in an act which is a crime. There's no allegation here that she was engaged in an act which was a crime. There certainly is not a Connecticut general statute referenced here as to which crime she was engaged in. Therefore, the defense could not properly defend against that charge. So we would submit there's insufficient evidence in regards to that. In regards to the paragraph 110/25, where the paragraph is characterizing my client's arrest as you assaulted the case manager. There's certainly no evidence here to support that there was an assault that took place. In fact, when the police did arrive, I imagine they had access to the same video that P.O. Sheehan is referencing that we did not have a copy of for this hearing. However, they didn't charge her with an assault. They charged her with a disorderly conduct. And then again, she did go to court, and the court found it appropriate to allow the information for the state. I found it appropriate to substitute the information, which means that the original charge of disorderly conduct was removed and replaced with a charge of creating a public disturbance, which is an infraction. So again, if you would submit, there's insufficient evidence to support that portion of the charge. In regards to charge 3, I have no comments. In regards to charge 4, just referencing the paragraph of 11025 again, it's characterizing assaultive behavior that there is no evidence of. And again, it references that the state police gave her a summons for disorderly conduct. And I would just again point out that that charge, the way the conduct is charged and alleged, it's referring to assaultive behavior. And there's no arrest that supports that there was an assault that took place. There's no evidence to suggest there was an assault that took place. And ultimately, my client was charged with an infraction. No further comments as to the charges.
Anything else before I announce my findings?
Nope.
I'll be right with you with my findings.
Mhm.
All right, so I'm going to announce my findings. So regarding charge 1, release direction curfew, I make a no finding due to the charge not meeting the elements. There's no evidence the offender had a curfew or what that curfew was. On charge 2, I find he violated conditional bail laws, obese law on part 3. This is based on evidence provided in support of the charge, which is Exhibit O, as well as testimony that was provided. Although the charge is slipped down, I do find the behavior meets the elements of the offense. A no finding is made on part 1 and 2, as that fails to meet the elements of the charge. On charge 3, I do find you violate condition or bail laws drugs based on evidence provided, which is exhibits H, I, J, part 1 and K and L on part 2. There is no finding on marijuana use, as that does not meet the elements of the charge of drugs. On charge 4, I do find you violate additional condition halfway house placement based on evidence provided, which is exhibits F and N on part 1 and F and O on part 2. So that includes the fact finding portion of the hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So P.O. Sheehan, would you like to say at this time regarding the seriousness of the offense?
Those particular 2 days were very out of character for Miss Castro. Other than those 2 days, she struggled with a lot of things, especially her medical situation. I felt like we had a very good relationship. We talked a lot. We met a lot. That particular day when she assaulted staff, when we came to get her, she also she refused to cooperate. She refused to speak. She attempted to trip me down the stairs multiple times. It was extremely out of character and very aggressive and violent. I was very, very concerned about her, very out of character for her. So it's really should be noted that not sure what happened. I do know that on her conditions, she has mental health, a stipulation for mental health. And if she were to be released again, I would like that to continue. She definitely needs to get back with the mental health treatment if she comes out again.
Thank you. Counsel?
Yes, thank you. Ms. Castro is 43 years of age. She's single. She does have 3 children who are adults, but she has received support, primary support from them, as well as her ex-boyfriend and a new girlfriend that she has. She does live with mental health issues, and perhaps she should be somebody that should be considered to be supervised by the mental health unit. I don't know if she presently is. She does suffer and live with substance abuse issues, which consist primarily of using marijuana. And so when you see the positive urine for fentanyl, she tells me that that was something that was in the marijuana. And so we had conversations about that she's not intentionally looking to ingest fentanyl, that she does utilize marijuana. She was in the community, I believe, for approximately 6 months prior to this violation. I believe this is her first violation of parole. She was released to discretionary parole on July 18th of 24, and she was placed at the Connection halfway house program in New Haven, and she RISE program, and she was there until the date of her remand. During the time that she was in the community, she reports being successful in an IOP at the App Foundation, which I think, to her credit, shows that she was taking some initiative to try to address the issues that she was having. She was involved with counseling there as well, she tells me. She received medication management services as well. She was unable to find employment during this period of time. She tells me that she does have some outstanding medical issues and that she would like to apply for disability so that she does have some support, financial support when she is in the community. I would note that during the time periods that she's been in the custody of the Department of Corrections, not just referencing this particular period of time, which is only, I believe, approximately a little over 2 months, but just addressing her time in DOC as a whole. She does have an OAP that consists of 2 programs, and she's completed those 2 programs during her time period in DOC. So I think that's important to know, that she is somebody that is with the structure, is on task, and does understand that she has those obligations, and she's completed them. Upon being re-paroled in the community, she'd like to be placed in a halfway house again in the New Haven jurisdiction. She is agreeable to all treatment recommendations. She would like to obtain her GED, apply for disability, and establish primary care services in the community so that she can address her medical issues. We would be asking, based on the totality of circumstances, I think primarily what we're seeing here is that the behavior and the conduct, I think P.O. Sheehan also touched on this, kind of occurring around the same period of time, was out of character for her, and that it is directly related to substance abuse. And so certainly she could benefit from being in the community and receiving those types of services. And so we would be asking that she be re-paroled at the next available date. Thank you.
Thank you. Anything else or anyone else before I make a recommendation?
No, ma'am.
Yeah. Can I just say
Yeah.
one thing?
Go ahead.
I did check on her when she got to York, and her urine was negative for illicit substances on that day. So was really perplexing for me because of her behavior. I thought originally that it would have been maybe some substance use, but she didn't have substances when she got to York. So it definitely stands out to me as some sort of a mental health issue. So I think it's really important to point that out because that's really what was going on for her, I believe.
Thank you.
And I can just note that during her time period in DOC, I believe that she has been medication compliant. So I think that helps address some of that issue.
I'll be right with you with my recommendation. So I have reviewed all the evidence provided as well as listened to testimony today. I will put on the record, offender was only in the community for about 5 months and 23 days before she was returned to custody on new charges, which were I do want to put this on the record. The addendum did report on 2/11/25. The charge was up to the infraction of creating public disturbance when she received a $50 fine for that charge. She does have a prior failed community supervision in the community. She is currently serving time for violation of probation. She does have 5 years probation to follow this period of incarceration. Based on the information I have, I am going to recommend that parole be revoked. He be re-paroled for May 9th, 2025. It's about a 4-month period of confinement as a sanction. I recommend the following parole conditions: halfway house placement, preferably, you said in New Haven, is that correct? New Haven.
Yes.
Mental health evaluation and treatment as deemed necessary, as well as behavior management program for anger management. My findings are going to the parole board March 27th. So the board's going to make the final decision. They can lessen the sanction, let it stand, or impose a sanction longer than what I've recommended. If they would like a longer sanction than what I've recommended, you'd have a supplemental hearing. And before the hearing, the board would provide you with written notice documenting the reason why they may want to exceed my recommendation. And during that hearing, you would have an opportunity to respond to those reasons in front of the panel of the board. So that is only in the event that they would like to hold you in longer. Do note the board can revoke all of your parole.
Yes.
And I recommend you to get involved in treatment as soon as you get out there to continue with what you're doing inside.
Yes, ma'am.
So I wish you the best of luck.
Thank you very much.
Thank you to both sides.
Thank you.
All right, thank you. Thank you.
Have a good day, guys.
You too.
Bye, Ms. Castro.
Bye.
Morning. Oh, you're muted.
Can you hear me now?
I can hear you. Yes.
All right, thank you.
Thank you. Mr. Hill?
Yes.
Morning, sir.
Morning.
We're here today for your revocation hearing,
Yes.
so we'll get started with that in 1 minute.
Okay.
Good morning. I am P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is revocation hearing concerning Hill Zera, number 122851. Today is March 19th, 2025. This hearing is being conducted via video at the BOPP Central Office, MacDougall Walker Correctional Institution. This is a public hearing and public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Ezra Hill, 122851.
You have counsel here today. Please identify yourself.
Yes, thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Hill.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. State, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better we do evidence must establish that, more probable than not, the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your parole, which is releasing and placing back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation be given to a panel for final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure. I'm going to read you your rights. Then we're going to review the parole violation charge, state your PL is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have opportunity to present all relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No.
Okay, you have important rights today, the right to have an attorney present, and you have counsel here. You received the written notice charges of violation. Did you receive that written notice?
Yes.
You have a right to view the evidence against you, right to submit evidence supporting your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
All right, so now review the charge. State your PO is bringing against you, and information underlying each charge. Charge 1, or bail laws, obedience to the law. You're charging off support at 11923. You attempted to illegally enter a private residence in the city of Stamford by standing on a garbage can, opening a window, and forcibly breaking the screen with residents occupying the address. A resident shouted at you to stop, but you continue to attempt to enter the residence. You were subsequently arrested by Stamford PD and charged with attempted burglary 2nd and criminal mischief 3rd. We'll put on the record, I did receive an addendum from PCS. The addendum reported on 2/19/25. You were convicted of attempted burglary 2nd, as well as criminal mischief 3rd. You received a 2-year jail sentence for attempted burglary 2nd and unconditional discharge for criminal mischief 3rd. I have an EOS date on that sentence of 2/19/25. So that sentence has been completed. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, Connecticut conditions of parole; B, remand of custody; C, notice of parole violation employee rights; D, parole violation report; and E, a Stamford PD incident report ending in 0020. Did you receive notice of parole violation report, and those other documents I marked, and did you review those?
Yes.
And council's filed the following exhibit pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No.
We have no witnesses today. So it's not a defense opportunity if I could speak to any evidence submitted.
Yeah, thank you. I would just indicate that in regards to charge 1, the addendum is stated correctly. His EOS date was listed as 2/19/25, but I would just like to point out that that's the date he pled in court. So he actually completed the 2-year sentence on January 23rd of 25. However, he didn't go to court until the 19th, and that's the date that he entered the plea. So he was over the 2 years in jail at the time that he entered into his plea agreement, and he's been held now for 26 months. Nothing further as to the charges or charge.
So I'm going to do next is on to my findings. So on that charge one, I do find you violated the conditional bail laws, obedience to the law. This is based on your conviction of attempted burglary second, received a sentence of 2 years jail, and criminal mischief third, and received an unconditional discharge. This concludes the fact-finding portion of the hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to.
Yes, thank you. My client is 58 years of age, single. He does have one adult child who resides in Bridgeport. He's a high school graduate of having gone to high school in Stamford, Connecticut. He indicates to me that he received some drafting certifications at Stamford, at Bryan Technical School as well. He was in the community for approximately 6 months prior to this violation. During the time period that he was in the community, he utilized the Isaiah Halfway House program and participated in programming through that house. He also sponsored and lived with his brother, Tony Brooks. He supported himself with disability because he does suffer from Parkinson's disease, which he was diagnosed with approximately 3 years ago. He also worked part-time for an irrigation company in Stamford. He's been in the custody of corrections now for approximately 26 months, having received a 2-year court sentence. I would note that his parole officer did recommend that his parole be revoked and that he re-parole at the end of his court sentence. He indicates upon parole reinstatement he'd like to sponsor to his mother's house, and her address and information is contained within Defense Exhibit 1. He also provides a second choice sponsor who is his niece, and her information is also contained within Defense Exhibit 1. He would like to reestablish his disability when he's released back into the community, as well as to be available to assist his mother. He's amenable to all treatment recommendations, and he would also like to reestablish his primary care to address his needs, as he does suffer from a significant medical issue. I believe he has approximately 14 months left on parole. We would be asking that he be re-paroled at the next available date. I believe that's in line with what his parole officer's recommendation was. And again, he's served in excess of 2 months in excess of his 2-year court sentence. Thank you.
Thank you. So I was testimony today, and I have reviewed all the evidence provided by the state. I will put on the record, this is the offender's first violation on this period of supervision. I see no noted misconducts. He did complete this sentence February 19th, 25, which received a 2-year jail sentence for attempted burglary second. He does have according to our records, has failed 6 out of 10 prior releases to community supervision. And he was on parole about 8 months before he was returned to custody on these new charges. The parole officer did recommend re-parole as well as halfway house placement. If you were placed in a halfway house, what area would you want to go to, sir?
I would go to Bridgeport.
Okay. All right, so based on all this information, I'm going to make a recommendation. I am going to recommend that parole be revoked to be re-paroled from March 27th, 2025 for a 2-year, 2-month period of confinement as a sanction. This is my next available board review date that I have. I recommend the following conditions. This is halfway house placement. That's only event you can't go to the sponsors, but your officer did recommend halfway house placement upon re-parole. So that's why I'm putting it in there. No consumption of alcoholic beverages, mental health evaluation and treatment as deemed necessary, and no contact with your victims, CEM and TZM. My findings to go to the parole board on March 27th. If the board agrees with me, you would be released that day. So you'll know they agree with me if you're released on March 27th. If you're there past March 27th, that means the board decided they wanted a longer sanction. And then you get a notice in the mail indicating the reason why. Then you would come before the board for a supplemental hearing, and the board would discuss with you why, if they would like the sanction longer. So just so you know, that is an option for the parole board. Do you have any questions?
No.
Okay, then you are all set for today, sir, and I wish you the best of luck.
Okay, thank you. Thank you.
Have a good day.
Thank you.
Good morning. You're still muted. Thank.
Can you hear me?
Yay! Yes.
It's been so delayed. I don't know what's going on with it, but I have Irizarry here for you.
Thank you so much.
You're welcome. Irizarry? You're right here, this room. Let me have a seat.
Hello, hello.
Good morning, sir.
Good morning, good morning.
We're here for your rev hearing today, so I have your attorney here, so we're going to get started, okay?
Okay.
Good morning, I'm P.O. Meisinger, I'm here an examiner for the Board of Pardons and Paroles. It's a revocation hearing concerning Irizarry Lewis, number 297854. Today is March 19, 2025. This hearing is being conducted via video at the BOPP Central Office in Osborn Correctional Institution. This is a public hearing, and public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Alex Vasquez, formerly known as Louis Irizarry, inmate number 297854.
Thank you. When you have counsel here today, please identify yourself.
Yes, good morning. Hannah Dean on behalf of my client, Mr. Irizarry Vasquez. Good morning, sir.
Morning.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that more probable than not the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your parole, which is releasing you and place you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we're going to review the parole violation charge the state your PO is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present a relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background history. Do you have any questions about the purpose or procedure before we begin?
No, Your Honor.
Your important rights at this hearing, which I will now review with you. The right to have an attorney present. You have counsel here. You have right to receive the written notice of charges of violation. Do you receive the written notice?
Yes, Your Honor.
You have a right to view the evidence against you before the hearing. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and you're ready to go forward?
Yes, Your Honor.
All right, so now review the charge. Is that the state your PO is bringing against you? Any information underlying each charge? I will put on the record charge 2, charge 3 are not taken into consideration as a no finding was made at the time of the preliminary hearing and there is no new evidence provided by the state. So charge 1 under release section GPS, you're charging officer reported 10/16/24. The offender signed the GPS monitoring agreement and was instructed 137 New Lab, Bristol, Connecticut is an exclusion zone and he is not to be at that residence due to his minor son residing there. On 11/23/24 from 3:42 p.m. until 5:16 p.m. the offender was at the exclusion zone residence. The offender violated the GPS monitoring agreement, which states, I will abide by all established inclusion zone requirements or exclusion zone requirements and must obtain prior permission from a PO prior to changing any established zones. Charge 4, no contact with minors. Your charging officer reported 119/25. New Britain PD was dispatched to the offender's residence at approximately 5:38 a.m. on a report that the offender pepper sprayed his roommate because the roommate woke up the offender's minor son. New Britain PD responded, smelled pepper spray, but could not determine who sprayed the roommate. New Britain PD stated the offender left the residence with his minor son. Therefore, the offender has in-person contact with a minor child without express permission of his parole officer. Charge 5. The parole officer reported on 12/23/24. The offender signed updated parole conditions with this condition added. The offender was instructed if he wants a device that has access to the internet, he will need to have monitoring software installed. On 1/24/25, the offender was found in possession of the tablet that did not have the monitoring software installed. The offender's screen time analysis shows he utilized the tablet from 1/5/25 to 1/24/25 for a total of 102 hours and 33 minutes. The offender created a Facebook page with the profile name Tortuga Trickster and Discord page with the profile name Officer Tortuga Vasquez. Charge 6 under problem sexual behavior treatment. Reporting officer stated on 7/16/24, the offender signed the CTPSV treatment agreement in which he acknowledged he is restricted from contact with children under 16 unless recommended by CTPSV staff and approved in advance by his supervising officer. On 1/19/25, New Britain PD was dispatched to the offender's residence on a report that the offender pepper sprayed his roommate because the roommate woke up the offender minor's son. New Britain PD responded, smelled pepper spray, but could not determine who sprayed the roommate. New Britain PD stated the offender left the residence with his minor son. The offender violated CTPSV treatment agreement by having unapproved contact with his minor son, which resulted in the offender's unsuccessful discharge for promise of behavior treatment. It should be noted the offender's legally changed his name to Ellis Vasquez, which is why the police report does not list Louis Irizarry. And the state has filed the following exhibits pre-marked for identification purposes as well, these were stated at the time of the preliminary hearing. We don't need to restate them. There are no changes to the evidence that was submitted by the state. Did you receive notice of parole violation report, and those other documents that we marked at the preliminary hearing?
Yes, Your Honor.
Yes.
And council's filed the following exhibit pre-marked for identification purposes. That's exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
We do not.
Okay, we don't have any witnesses today. So it's now defense's opportunity, if you'd like to present any evidence, speak to any of the evidence submitted at this time, Meg.
Yes, thank you very much. So I just wanted to clarify, you said that you were not considering charge 2, that was a no finding?
Correct, charge 2 and charge 3.
Okay, thank you very much. So I'm going to just refer throughout to my client as Mr. Vasquez, but just as it is known, he was formerly known as Louis Irizarry. I just wanted to clear that for the record. So as to the first charge of GPS, I would argue that the preponderance standard has not been met. Although the GPS agreement is an evidence and the event history, we don't have any exclusionary zone maps that have been submitted to evidence, and the GPS event history doesn't actually show the client's GPS points on the map. So I would argue that it's unclear based on the submitted evidence whether my client was on notice of the specific exclusionary zone from which he had to stay away. So I would argue that the evidence is insufficient for that specific charge. As to charge 4, no contact with minors, and charge 6, I would say, because it's similar conduct for each. My client indicates that this contact was in no way intentional, and he was not alone with his son at any point, as his son did not stay the night. He indicates that his sister was watching his minor son. On the way back to drop the son off, she was passing through his side of town and had to use the restroom. She, my understanding is, did not disclose to my client that his minor son was with her. And my client thought, okay, she's just stopping by quick to run up and use the restroom. My understanding is that she came upstairs and did bring the child, but my client was not apprised of the fact that she would be bringing the child there. So in no way is that intentional conduct. I would argue that the standard has not been met there. As my client was not noticed that this was a concern. In addition, I also just want to put on the record that a DCF referral was made on the date of this alleged incident, 1/27 of this year, regarding the allegations of my client having contact with his minor son. And I will just note, as the commissioner of the Superior Court, I do owe a duty of candor. So I will state that I did receive records from DCF. Due to the confidentiality, I did not ask that those be put in evidence, but I give my word as a commissioner of the Superior Court, I obtained those records. And the case was actually closed out on March the 10th. And there was no substantiated allegations. Specifically, the closeout note states, at this time, there were no needs that are not being addressed for the child. He appears to be doing well. There were no safety concerns identified during the investigation. The allegations were unsubstantiated. So I did just want to clarify that for the record, that DCF, which I would argue is maybe the more appropriate entity to be considering these issues regarding child welfare, did do an internal investigation and they found nothing to be substantiated. So I did just want to clarify that. As to charge 5, the enhanced internet and device monitoring, I would argue for that the preponderance standard hasn't been met. I understand that there are some images and evidence and that the allegations are my client had potentially access to these devices. However, it's unclear based on the information that's been submitted as evidence whether it was actually my client himself who was accessing these devices. And in fact, I know that at least one occasion, I believe, his wife had actually called to put Parole on notice that she was the one accessing some of those matters on the device. My client has been clear that those devices were not his. They were left there inadvertently by his wife. He was not accessing them. He was not accessing these things. So I just want to make that clear. So those are the comments that I have as to the actual charges. And at the appropriate time, I would like to remark on his background and future plans. Thank you very much.
Thank you. I'll be with you with my findings. So I am going to announce my findings regarding that charge 1. I do find you violated condition GPS based on evidence that was provided in support of the charge, which is exhibits B, C, G, L, and O. Regarding, as I said before, charge 2 and 3 are not taken into consideration today. Charge 4, I do find you violated that condition, no contact with minors based on evidence provided, which is exhibits B and M. On charge 5, I do find you violate condition enhanced internet and device monitoring based on evidence that was provided in support of the charge, which exhibits B, C, G, K, and N. And on charge 6, I do find you violate condition problem subject behavior treatment based on evidence provided, which is exhibits B, F, I, and M. So that includes the fact-finding portion of this hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Yes, thank you very much. My client, Mr. Vasquez, is 39 years old, born and raised in the Waterbury area. He receives his primary source of support from his wife, Genny Vasquez, his sister, Betty, his sister, Shakira, and his best friend and supervisor from a previous job, Mr. Matthews. He also gets support from Mr. Matthews' adult son as well. My client and Ms. Vasquez do have one son together who was born last year in March. Most recently, upon release to special parole supervision, my client successfully completed Renaissance Central Halfway House and was then self-sponsored at an address in New Britain where he remained until his remand. Previously, while on supervision, my client was released in January of 2020. He utilized from January until April the January Center, successfully completed that, and then was sponsored by himself and then his wife for a period of time prior to the birth of their son. He was reportedly interested in enrolling in adult education at that point to get his GED and further his education. He previously worked for Emily's catering group out of Bristol and was actively searching for additional employment. He reports that he had obtained a position at McDonald's, though was eventually denied the opportunity to work there due to there being a playscape there. However, he had obtained that position and was looking forward to starting. In January of 2025, the 14th, my client completed an intake assessment at the AIC program through Wheeler in New Britain. He participated in the reasoning and rehabilitation group on January 24th of this year. He also did the Connection Center CTPSB program and was reportedly in phase 2 at the time that he was remanded. May 8th, 2020 until October 21st, 2020, he had successfully completed the CTPSB program. We got documentation saying that he was attending consistently, was engaged and doing well in treatment there. He also reports attending outpatient services at CHC in Hartford, including medication management. My client is registered with the Sex Offender Registry, is compliant. Since his incarceration, he reports medication compliance. He's had no disciplinary issues, and he also reportedly wrote to Addiction Services and Mental Health for programming. Upon reinstatement of my client's special parole, he would like to be placed in an apartment through Chrysalis Center in Hartford. Should he be placed in the halfway house, he's requesting, I believe, the Hartford jurisdiction. Is that correct, Mr. Vasquez?
Yes, ma'am.
Thank you. He's also hoping to enroll in adult education to get his GED. He's open to any sort of work recommendations, and also he's open to any sort of treatment recommendations, including doing the medication management, doing the CTP-PSB program, and anything else that's asked of him. I would argue that these are technical violations only. My client got no new criminal charges for these allegations, despite involvement of police allegedly for that incident in January. He has absolutely no disciplinary issues prior to that. He's been on supervision since 2020. This is only his second violation. My understanding is that prior to the first violation, he was doing absolutely phenomenal in the community, had no even DRs or incidents from that period. He was only remanded once before for a failure to register that I do not believe was intentional. I believe it was a mistake, and he did resolve that. I will just note from speaking with both my client and his wife, it appears that there were a number of concerns regarding his parole officer here, which are very unfortunate. Specifically, my understanding is when his wife got pregnant, they were very excited about this news. My understanding is that the PO actually told them you didn't have permission to have a child, which, you know, I think is a little bit crazy. My client, I believe, has been doing absolutely everything that he needs to do in order to go through the correct channels to, you know, address potential contact in the future with his child. However, he has not been trying to circumvent that process. My understanding from him and his wife is that they've gone through the process a number of times, submitting the appropriate paperwork, and felt as though they were submitting it to the PO to no avail. There were a couple times, I believe, when they contacted either program personnel or victims advocates to determine, okay, have you gotten the paperwork? And they were told on those occasions they hadn't even received it. So I think, you know, it has been somewhat frustrating for both my client and his wife, because they're trying their hardest to do the right thing. I mean, he is somebody who's been on parole for quite some time, has really not had any issues. I don't believe he's an issue in the community. He's been putting his head down and doing what he needs to do as far as treatment goes in order to move forward. I would argue that my client should not be given a sanction to exceed 2 months. He's already been incarcerated for about 2 months at this point. Again, these are technical violations. He has been trying his best to go through the right channels. So that would be my argument as to Mr. Vasquez, and I'm asking for a sanction not to exceed 2 months. Thank you very much.
Thank you. So I'll be right with you with my recommendation.
Thank you.
So I will put on the record, after listening to testimony and reviewing all the evidence provided by the state, I will note the offender was on special parole for about 8 months before he was returned to custody on this violation. He does have a prior criminal violation in which he received a 7-month sanction. He has received 3 noted misconducts on this period of supervision. He does have, according to our records, 1 failure on community supervision on a prior supervision. He's serving 10 years special parole with an end date of special parole in January of 2030. The PCS officer is recommending a 1-year incarceration. I do take into consideration findings made today, as well as no findings that were made at the time of the preliminary hearing. Based on the information that I have, as well as all the testimony, I'm going to recommend that parole be revoked to be re-paroled for August 25th of 2025. This is about a 7-month period of confinement as a sanction. I recommend the following parole conditions: halfway house placement, restriction on pornography, behavior management program for anger management, no contact with your co-defendant Terrence Ortiz or Lester Quinteros, no contact with your victim MJ or LI, enhanced internet and device monitoring, mental health treatment, medication compliance, no contact with minors without PO's permission, and problem sexual behavior treatment. My findings are going to the parole board on March 27th. The board's going to review this. The board can lessen that sanction, let it stand, or impose a sanction longer than what I have recommended. If the board wants to impose a longer sanction than what I've recommended, you'd have a supplemental hearing. The board will let you know the reason why they would want it, and then you'd appear before them for that hearing if they do want to exceed my 7-month recommendation. Do you have any questions, sir?
No, but I can, all I can say is that I'm just trying to go home to my wife. I've been doing everything that necessary to at least be the father that I never had, but I'm being restricted and prevented from doing so. I've been through the process. I've done everything necessary to be home, to behave, I haven't even been violent, no violence at all. And I have a history of violence. I've controlled myself. I've been peaceful. I've been honest. Okay, maybe a lot of people may think I'm an asshole, excuse my language, because of my honesty, but that's just me being honest. A lot of people don't like it, but honestly, not my problem, At least I'm being honest.
Okay.
Would you rather have somebody honest than lying?
No. I understand what you're saying. I understand you expressed your frustration for going through processes and not happening as fast as you like. So I do understand that, but you still have to go through the process. I hope this time that this process works out faster for you. I don't know what, I just hope everything works out well for you when you go back out. Just be patient with the process and do things the right way so you don't come back here.
I'm trying my best. I'm doing my best, It's just a lot of people don't.
That's why I understand that. And that's why, I gave you the sanction that I did give. And I hope that you do well out there. And we do recognize that you are doing things right, but things happen that were, shouldn't have happened. And learn from this and move on and, pick up, do things through the right procedure with your whoever officer you get. And hopefully you can have contact soon, permission. So I wish you the best of luck, sir.
Alex, I'll set up a legal call with you for the date of the board review so that I can update you on what they decide. And I can also update your wife as well if she has any questions about what happened. Okay.
Please. Thank you so much.
All right. Thank you very much. I hope you have a wonderful day. Thank you.
Okay. So you're all set today, sir. I wish you the best of luck. Thank you to both sides. Thank you, Attorney Dean.
Thank you. Thank you so much, Alex. See you soon.
Yes, ma'am.